A and B. Officer, your name?
Officer McCardle.
Officer, raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you've given these proceedings will be the whole truth self you got.
Yes, Your Honor.
Okay, go ahead.
On March 2nd, 2026, at approximately 21:32 hours, Officers Jarmo, Miley, and Hunter were dispatched to the Flat Rock Mire in reference to a male with a knife threatening an employee. Upon arrival, Officers Miley and Hunter made contact with the subject inside the front entrance of the business. Officer Jarmo arrived and made contact with the complainant/victim, Jeremy M. Roos. Contact with the victim. Roos stated that he is the manager of the store and was alerted by an employee of a suspicious male that had entered the store. The employee advised that the male had a knife on him as well. Roos was able to locate the male, later identified as Michael Teets. Roos began to stand in the aisle near Teets and observe his actions and to identify if he had a knife on him. According to Roos, Teets began to question Roos why he was standing near him in the aisle and why was he watching him. Roos informed Teets that he was the manager and he was just walking around the store. Teets accused Roos of watching him and he positioned himself into a fighting stance while staring at Roos. Roos advised that Teets had puffed out his chest and clenched his fist while speaking and staring at Roos. Roos stated that he observed the knife on Teets' person. Teets never reached for the knife, brandished it, or threatened to use the knife on Roos. Roos stated that he was nervous that Teets would use the knife against him, however, and he left the area out of fear of being stabbed. Roos began to contact the Flat Rock Police Department to report the male inside the store. Roos further stated that he went to a different location in the store while he was on the phone with the police. Another employee approached Roos and informed him that Teets was asking for him as he was going to mess him up. Roos stepped outside of the business to wait for the police to arrive. Roos advised he wanted the male trespassed from the business and he would like to pursue charges.
What business was this?
This was Meyer, Your Honor.
All right, based on your sworn testimony, I find that the crimes of disorderly person, public intox, and assault were committed, simple assault. There's probable cause to believe those crimes were committed by the defendant. I'm going to authorize the issuance of the complaint and the warrant on those charges. You'll just give me 1 second. And Mr. Haynes, your appearance.
Thank you, Your Honor. Joe Haynes, that's Michael Teets.
Mr. Teets, your name.
Michael Teets.
All right, for purposes of arraignment, how does he wish to proceed?
We wait for formal readings.
Entering a not guilty plea on both of these. Sir, I'm going to advise you of your rights. You do have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You don't have to choose to submit to questioning with law enforcement officials, but if you choose to, you have the right to be represented by your lawyer at that questioning and again at all subsequent court proceedings. You understand that?
Yes, sir.
I'll give you a court date, March the 19th. That will be your pretrial date, March the 19th, and that will be at 10:15. Does your client have a record?
Does he had a OWR from 2024? He tells me successfully completed probation.
Anything you'd like to say regarding bond?
I think that's all he's got. I know this is quite a serious charge. He doesn't have any money, does side jobs, can't come up with much as far as bond. Doesn't sound like he could come up with more than $100 to get out. And I think that this court's now in session next week, and then that's here in the Flat Rock case, the 19th. So he would be stuck in custody until, my understanding, he's got a court date next week, Judge Bassett. And I believe he's got a personal bond on the 12th. Under those circumstances, I asked the court to consider a personal or very long bond.
Officer McCardle, anything?
Up to the courts, Your Honor.
You cannot leave the state. These are your bond conditions without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume marijuana. You're not to purchase, possess, or consume illegal controlled substances. You're not to possess any firearms. You're not to possess dangerous weapons. You're not to enter the property address at 26100 Vreeland in Flat Rock or any other Myers store. You're not to have any contact with employees of the Flat Rock Myers store. You're not to have any contact with Jeremy Roos. You cannot write, phone, see, text, email him, or have anybody else do any of those things for you or on your behalf.
Okay.
You're to
That's no
attend
problem.
AANA twice a week. That's to be in person. You're not to possess firearms. You're not to possess dangerous weapons, no knives. So no contact with Jeremy Roos, no contact with prosecution witnesses or employees of Flat Rock Myers. And you're not to enter or go near 26100 Vreeland in Flat Rock or any other employees of any Meyer. No alcohol, marijuana, or illegal drugs. No firearms, no dangerous weapons, no knives, no alcohol, no marijuana, no illegal drugs. I'm sorry, I'm not giving them a personal bond. 4,010%. You have to post $400. Your court date is March 19th, and that will be at 10:15 in the morning. 10:15 in the morning. So you can make some calls, and they'll let you do that, but you're going to have to come up with $400 to secure your release. If you want a court-appointed petition,
He's filled out. Judge.
okay, good enough. And then make sure you give them an AA verification if you post that bond, officer, okay?
Yes, Your Honor.
Thank you very much. Thank you. Thanks. Give me 1 second here. Is Mr.
Well, I'll take it over.
Is Anthony Malmston out there?
Yeah.
All right, because I want you to explain something. Bring him in. Mindy Elaine Malmston, 25B 722-119.
And we on behalf of the people of the ACES 538.
I need Mr. Malmston brought in.
Bringing him in.
Your name, Mr. Darren?
Nicholas Darren on behalf of Ms. Malmston.
Ms. Malmston, your name?
Mindy Malmston.
So come on up here, sir, if you would, please. So I need to advise you, Mr. Malmston, your name, sir? Good morning or good afternoon. As I was heading to my chambers just now, I was handed a sheet, a paper that you wrote to me, and they said that you didn't want me to share it. If I read this, I have to let the defense see it. I want you to know that.
That's fine.
So you understand I'm going to read it.
Your Honor, if I have just 1 moment.
That's a minute letter.
This is an email that was sent today, it looks like, at 1:51. It was sent to Laura Dodge.
Your Honor, that is the statement, the victim impact statement that we,
So what I'm trying, I get it.
Yes.
Hang on.
Yes.
What I'm trying to tell everybody is I can't have secrets here. So I will, if I'm going to read this, he has to understand I'm going to let the defense, I'm either going to read it out loud so they can hear it, or I'm going to give them an opportunity to read it.
Your Honor, he did not want to say it himself. We asked that the court say it. So
It's fine.
you may read it aloud.
Okay. So your client pled guilty to domestic violence under 76948. And this is the page that I received. Your Honor, thank you for allowing me to speak. My name is Anthony Malmston. I've been with Mindy for 25 years and experienced over 2 decades of verbal, emotional, financial, and physical abuse. Looking at the past year alone, there have been 5 domestic violence incidents involving me and our 3 children. She's caused fear and instability for our family. The children were present during all of these incidents and were physically and emotionally affected at times. As a result, the children and I are in long-term therapy and receiving ongoing treatment for complex PTSD stemming from years of abuse. I am not here for a revenge, but to ask for meaningful accountability. Given the number of incidents and the impact on our family, I believe the proposed sentence is far too light. I respectfully request a comprehensive mental health evaluation, mandatory anger management counseling, and regular drug testing. I also ask that she follow any doctor recommended treatment plan, including remaining compliant with prescribed medications, which has been an ongoing struggle. Our family has relied heavily on First Step for support and counseling services. I ask that she be required to contribute to the Victims Fund to support future victims, John. I also request that the no contact order be upheld, extended, and strictly enforced, as she has been accused of violating it 3 times in the past 6 months. My priority is the safety and stability of my children and family. I ask the court to ensure accountability along with the appropriate treatment. Thank you. Ms. Holloway, correct me if I'm wrong. There was no alcohol involved here, was there?
I'm just gonna take a second to confirm.
Please. I read the report. I do not remember seeing any mention of alcohol or drugs being involved.
There was no.
So that, just so everybody knows, I don't order that kind of a no alcohol or drugs unless it had something somehow, some way to do with the incident. There's no indication that it was here. Have you had a chance to review the screening and the pre-sentence report with your client? And are there any material additions, corrections, or deletions?
Yes, Your Honor. So I guess one thing to address, we placed this, I know we came in on Zoom kind of last minute right before the trial to put this on the record. At that time, the offer that was tendered was 7694A for a 6-month probationary period. You said you would go along with that. You actually brought here the victim in this matter, and he said that he was in agreement with that as well.
Did you have a 6-month agreement on this?
Yeah.
I don't usually do sentence agreements. I can tell you that. Okay, that's what you're recommending. Did you take that as a sentence agreement?
Well, yeah, well, yes. And then when you said, I'll go along with
Let me
that.
go listen to the tape. If I said, yes, I'll go along with it, I'll go along with it. I'm gonna go listen to the tape. We'll pull out the log notes. So you guys will have to be seated for a few minutes while I go on to a couple of one of these. I don't do those.
And I do know she said it was a recommendation. She said that, and then Miss Holloway, sorry, I apologize, said that this was our recommendation.
And I said,
We'll go along with that. And then we took the plea. You asked Mr. Malmston.
I don't want you telling me how many months I'm gonna do anymore then. Will you do that for me? Usually I do less than you guys ask, but I'm not gonna do less when you guys put down 12 if I can't do more when I think it might justify more. I'm not saying it does or doesn't here. I got a lot of questions in my own brain here, like a 26-week domestic violence program. I don't have that in my brain. This assault was not serious enough. Not that any domestic assault isn't serious enough, but I'm not ordering 26 weeks domestic violence batters counseling when there's a simple push. I'm not doing that.
Make recommendations as per your request. So I would.
Well, my request is always leave it to me, right? I want to be able to be the sentence. I don't do Cobb's pleas. I haven't done Cobb's pleas since 1995 or 6. And I'm not starting today or anytime between now and the time that I leave. So if you really were that insistent on 6 months, I'll go listen to the tape, but you guys just have to be around here.
It's fine.
No. Is that what you want me to do?
I would like you to listen to tape because outside of all of that, Your Honor, and if the negotiations between me and Miss Holloway.
She's not the prosecutor, or she's not the judge.
I understand she's not the judge. I got that.
So that's what I understand is when lawyers start telling me what they think of do, and I'm not gonna go along with these sentence agreements. This is silly.
I understand, but what I was.
So I'm cutting it both ways here. I'm not gonna go along with the 26-week recommendation because it doesn't merit it. But if I think more than 6 months is merited, I don't want some lawyer telling me you or anybody else, you agreed to 6 months. If I agreed to 6 months, I'll honor 6 months. But it's going to just take us some time. My regular recorder isn't here.
I would,
My regular recorder isn't here. I'll be glad to look at it. If I said I'll go along with that, I might have meant 7694A. I got to listen to the context.
I mean, my memory is good, not. I remember you saying that. I guess
You want 6 months, probation recommends 12. That's where we are.
well, I think if you could pass it for 2 minutes.
I'll be glad to do
Let me
that.
talk to my client because I think I think she has a different concern really than the length. So if that's the case,
I'm going to be fair with her.
I won't dispute that, Your Honor. I've been in front of you for 13 years.
I know. Okay, you can talk to her, but honestly, if I said I don't want anybody to walk out of here thinking that I'm going to change my mind without offering them the opportunity to withdraw the plea. So if I said I'll go along with 6 months probation, then I'm going to go along with 6 months probation.
No, absolutely.
You know?
I fully understand that.
Okay,
Just give me
have a conversation, take your time. I'm gonna real quick take Rakeem Deshaun Gadsden, 25F244729. Flat Rock's here this afternoon.
Yes.
All right. Come on up here, sir. Your name? You're charged with driving on a suspended. You have the right to a lawyer. Do you want a lawyer?
Yes.
Where you been? Why is it taking you 6 months to come in here? I'm gonna give you a lawyer. You can talk to your lawyer about what you're gonna tell me as to why you were so late. We're not a restaurant here, okay? Got it?
Yes.
I'll give you a lawyer. Flat Rock prosecutor's here, right? Yeah, I saw Mr. Keeley. All right, we'll set you up with a defense attorney. Go out in the hall. He'll set you up and you'll be all set, okay?
Okay.
Summer Greathouse. Summer Lori Greathouse. 25F245336. Give me 1 second, Mr. Lawrence. All right, your appearance?
I hear the call on representative, right?
Ma'am, your name?
Summer Greenhouse.
This is going to be a plea to operating while visibly impaired, correct?
That's right.
They're going to dismiss the operating while intoxicated, correct?
Correct.
Correct me if I'm wrong. Somebody dropped the ball here. This is at least your third drunk driving. Right?
That's true, Your Honor, but the first two is she was in her early 20s.
I'm just telling you what the law is and what I see. I mean, I've seen them enhanced from 2002, 1996. I don't write these laws. They don't talk to me about them. But I want her to understand they could have charged a felony. And I want her to understand if you don't get into sobriety court, you're going to go to jail on this. Do we understand one another? So does she understand that? Have I alluded? So you understand what sobriety court is? Could you talk to the sobriety court probation officer?
Ms. Wilds?
Yes. So you understand that when we do this now, I'm going to put you on a bond conditions. She's going to put you on bond conditions, essentially. You're going to start going to treatment. You're going to start testing 3 times a week at your own expense. You're going to have a sober link device, which you already have. I believe I would have ordered that. If I didn't, I dropped the ball. She has a sober link, right? You're going to be going to AA. You're going to have to come to status review hearings with me every other week. And in the off weeks, you're going to have to meet with probation. This will go on for 2 years. We'll put you through a bond phase. And after about 5 weeks, the team will meet. We have defense lawyer, prosecutor, treatment specialist. We're going to decide whether or not we're going to accept you. And if we accept you into the program, that's great. I'm not promising I won't send you to jail if you get in, but I am promising you I will send you to jail if you don't get in. Do we understand that? You still want to take this plea? I'm just trying to be upfront with you here. Do you understand everything? If you plead to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs, or all 4 points, license suspension or revocation in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that? And did you sign, read, and understand an advice or rights form here today? If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? Any questions before I go on? To the charge operating while visibly impaired, how do you plead? On December 11 of 25, were you operating a motor vehicle on East Trent River Drive near Sheik's Flat Rock at 11:53 p.m.? Prior to that, did you drink alcohol? And if so, what did you drink and how much? I need you to keep your voice up.
Was drinking White Claw, and I probably had 7.
And what else? What else did you drink? Nothing else? Just 7 White Claw? You were pulled over by the police, correct?
Yeah.
Why?
I'm not sure.
Do you think you did anything wrong in the operation of the vehicle? Were you swerving, weaving? Was there an accident? Did
It
you,
was not an accident. I may have been swerving.
do you think you were swerving?
Yes.
Do you think you were swerving at least in part because of your alcohol consumption?
Yes.
Was this was a blood test, wasn't it, counsel?
Yes, ma'am.
Do you stipulate that the reading of 0.271 was an accurate reading?
Yes, sir.
Are you on probation or parole right now?
Yes, sir.
Anybody force you to plead guilty? All right, please accept the operating while impaired. The OWI is dismissed. There's agreed upon cost of recovery of $225. I'll make a note that this is going to be sobriety court. We're going to do a screening and assessment. Now, I'm going to order that your vehicle be immobilized as I must because you got a prior 2 years ago, 2.5 years ago. So I have to order a mobilization of your vehicle. So you're going to have to call a company. We're going to give you the order. And it's going to put, you're going to have, I'll give you the minimum. It's 90 days. So you're going to have a club put on that steering wheel within 7 days by March the 10th. We'll prepare the order down the hall. Make sure you get that. Now, I'm not excited about the fact that you were drinking in violation of the bond conditions. I'm going to let that go. But you got to get back up. You're going to die if something bad, this is crazy. Okay. You seem like a nice lady and all that, but you got to get your life in order here. Okay. So we'll do it through sobriety court. You're actually going to enjoy the program if you embrace it. If you don't embrace it, if you're fighting it the whole time and going home every day saying this is miserable, I'd rather spend 365, actually 730 days in a dentist's office getting root canals every day. You follow me? So I need you to embrace it. If you go through this bond phase and you say, I just don't want to do this, that's fine. I just, there's going to be severe consequences to that. But I wouldn't go through sobriety court to send to just appease a judge or my spouse or my friends or my parents for 2 years if I thought it was the worst thing in the world and I wasn't intent on getting myself some lifelong help. And I'm being honest with you. Okay? Because the whole concept here is we got to get you away from this because you're only what, 38? 3's a lot. If they'd have enhanced this, there are judges in Detroit that would have sent you to jail. You were convicted of a felony. A lot of them, okay? So I'm just telling you. So we'll give you a sentence date. You get the immobilization order. Let's get going. There's no reason for you to be scared. Just embrace the program. Believe it or not, I'm on your side. Okay? All right, give me a date if you would.
Judge Hubbard, did you want this out a few weeks?
Yeah, I'm going to think like the 12th or 14th or something like that of April, around there.
Okay. And you have sobriety court on April 15th?
Perfect. We'll make it at 8:30.
On April 16th, right?
15th. You said 15th, right?
Correct,
Yeah.
Judge.
You can't do the 15th. What if we do the 14th? Can you do the 14th?
I think so.
Let's make it the 14th at 8:30. The more that we put it out there, the more she has to pay for her own testing and sober link and that kind of thing too. So I don't want to go any further than that. Okay? You all right? All right, thank you both. Good luck. All right, come on up. What do you have, Mr. Mays? You got something?
Teasdale, Your Honor.
Is that a real quick one?
Yes.
Where's the file? You have the file?
Prosecutor brought it in, I thought.
Okay, give me 1 second. Did you figure out what you want to do? You want me to?
We're gonna proceed.
You sure? Because I'll go listen, and if I said that, I'm telling you, I will not go back on my word.
I told you both that, but
All right, let me talk. Lauren Rose, Louise Teasdale, 25F245343. Good morning.
Thank you, Judge. William Mays, I've got Ms. Teasdale. Ms. Teasdale, say your name.
Is this a first offense?
Yeah, and we're still waiting on discovery. We had a pretrial a few weeks ago. I'm gonna send over an email to remind the prosecutor.
All right, so second. All right. Pretrial date, couple weeks out. March 17th, good?
I know I got some stuff that day, but let me,
Are we going to trial on this, Mr. Mays?
nope, what?
Are we going to trial on this?
I think, no, it's just a question as to how generous an offer the prosecutor's gonna give me.
Judge, it would be March
Yeah.
19th for Flat Rock.
March 19th,
Oh, 19th. 19th I can do.
8:30.
Oh, 8:30?
You want me to do 9?
I thought we were doing afternoons.
I don't do afternoons.
It's,
I am today because I'm gonna be out of town tomorrow. We had to reschedule the docket.
no problem. Thank you, Judge.
Can you do 8:30?
Yeah, I can.
Okay, 8:30 on March 19th. Did I already sign your discovery order?
I don't think it even required an order. It was just a demand.
Good enough, good enough.
Thanks, Judge.
Go, take her down, she'll get her
And
notice.
now I'm gonna start to ask for cops.
No, I
Once
don't-
I hear this,
I-
I'm gonna start to ask one.
I said I don't do
Oh,
cops.
that's what I am. Thank you, Judge.
Maybe Lane Malmston, 25B722119. I need your appearance too, Ms. Holloway.
That's Nora Holloway, Department of Legal, PA 6528.
ready again, Your Honor.
All right, come on up here. Your name, ma'am?
Mindy Malmston.
All right, counsel, your appearance.
Nicholas Darren, the defendant who stands my record.
All right. You've reviewed the report, right?
I have, Your Honor.
Any material additions, corrections, or deletions?
No, I just have some things to say.
Sure, go ahead.
So, Your Honor, this all has arisen, and there's a relatively nasty divorce case that's going on as well alongside of this. This case, in conjunction with litigate the whole divorce case, I'm sure you've seen this enough times. There's been issues with the minor children, people not following orders, houses are being ordered to be sold, things of all that nature that have, pumped up the animosity in this case as well. Your Honor, I think you nailed it on the head when you looked at the report. I would say the video was similar with the officer's conversations with the victim in this case. I agree with you. I don't think that the 26-week domestic violence program is necessary in this one. There was a order in the family law. One thing we did discuss was contact pursuant to the Third Circuit Court because there is orders in place that allow her to see her minor children. I'm not even going to get into how that's been going because of various outside factors. But, Your Honor, at this point, these parties are essentially electricity and water. If my client said the sky was blue, the victim would disagree. If the victim said that water is wet, my client would disagree. Me and the counsel in the divorce case are doing our best to try and bring some sort of sanity and semblance to this case. They've been urged by the Third Circuit Court judge to try and put down their swords and come to some resolution. We are going to mediation, I believe, later this week or early next week, with where I have hopes that we'll reach some sort of settlement in this matter. I'll be honest, Your Honor, I don't think you're going to have any problems with my client on probation. She has no prior record of any kind. I think she's going to be a model probationer for you. I think she'll be in compliance. She works full time for the United States Post Office, and she wants this behind her as much as possible. She wants to move forward. At this point, she's come to some realization with the other case that there has been damage done that's only time will heal. And no matter what she wants, it's not going to happen at that certain rate. So, Your Honor, I just ask that you obviously make some corrections to the recommendation, but I do believe that whatever term you place her on for probation, this will be the last time you see her. I don't think there's going to be any issues. These two parties, I understand that there's a request for a no contact order, but these two parties are going to share legal custody of these children. They're going to have to communicate about these children. They're going to have to communicate to do parenting time, to do exchanges if something happens to a child. So if this court continues and just does a flat no contact order, I'm sure you'll be back. You'll see Mr. Malmsteen come in here and say that there's been contact because, oh, my client went to the school or something like that to see her kids and he was there. Or, oh, they had a conversation because the child was sick and she needed to relay that information to him. So I just, as I'm sure you've seen countless domestic violence like this before in front of you where there's a pending divorce case and you understand the heightened level that the parties give it. But at this point, Your Honor, my client, like I said, will be a model probationer. I don't think there'll be any issues. And I ask you to follow the recommendations with some of the modifications as I had mentioned and you had mentioned previously.
Can I ask you a question, sir? Do you mind coming up here? Or would you rather not? Come on up. Your name? I'm looking at this report again, and there's like a supplement that talks about Norco and Adderall.
Yes, for the last 10 years, Mindy has made me give her half of my medication every day,
That's fine.
which is yeah. She's suffered from many alcoholic and drug problems throughout the 25 years and been in treatment.
Have you been in treatment?
No, sir.
She reported to your probation department that she's with Dr. Yee and that she gets a medication. I mean, that's not, I didn't correct it because that's what it is. I mean, she is openly disclosed that. So again,
I've seen Dr. Yee for 10 years.
Your Honor, like I said, this one hits my top 10 list as far as divorces in 15 years. So, and I mean, we can, like I said, I'm not really interested in litigating the case on the whole thing, but she hasn't seen her kids since this incident. And
Your Honor,
there's, go ahead.
if that's in the report, I have no objection to a recommendation for treatment. I don't see any harm in an evaluation.
Well, what's the treatment? She's already with someone who she's been treating with for 10 years.
Well, I'm not worried about that. She's going to continue to treat with him. That's not the issue. I don't even need a psychological evaluation. I'm concerned about this additional interview that I'm just seeing.
But and if it's the additional interview, I'm thinking that's when he came back to the police department after the fact to then info dump an additional set of facts, which I'm, again, out of respect for him, I'm not going to bring up most of that. So, Your Honor, like I said, there was an arrest. There was this report, which is the initial report. And then he comes back with the eldest child, who him and her have been in here at every court appearance, posting on Facebook, taking selfies in your courthouse about how they're here to put and take care of the wrongdoer. So, I mean, Your Honor, like, when I say top 10, I've done thousands of divorces. It's everything.
All right.
Rightfully made a report. He went back and made other reports, so that, I believe what you're looking at is a part of other reports. Or other reports were made from that supplement. So if there are allegations to that, again, I don't see any harm in an evaluation, and I would have no objection to your recommendation for that.
I'm talking about abstaining from the use of alcohol and drugs. I don't see any incident where this was involved in this incident. In other words, I don't see any reference in a report where she was under the influence of alcohol or drugs or both at the time of the incident. He didn't say it then. He's talking more about past history. What I'm going to do is this. Do you have anything else you wanted to say?
Just that I did review the PSI. It does say 12 months. Nick and I did speak about, or Mr. Darren and I did speak about 6 months. But for the record, I have no objection to the court following the recommendations of the PSI. If we so choose.
How old are the children?
They're the eldest is 21, then there's 14 in.
I don't care if they're 21, 14, 8, or 56. You guys cannot get your children in the middle of your issues. You cannot do that. That is so incredibly harmful to a child who loves, I'm certain, both of her parents or his parents. You cannot do that. I don't care how much you want to do that. I don't care how much satisfaction you get out of turning a child against the other parent. And I'm referring to both of you. You cannot do that. That cannot happen. I'm not talking to anybody in particular here. I'm just talking to both of you. 9 months probation. If I let you finish, did you want to say anything else?
No.
I mean, if there's one thing I've agreed with is what Mr. Darren said about the circuit judges, including them to put their, or encouraging them to put their swords down. You cannot do this, folks. Okay, so you're not happy. People get divorced in this country every single day. Not just one couple, probably thousands. I mean, I don't know what percentage of marriages work to the point that they last forever, but okay, so you want a divorce. I get it. Maybe one of you do, maybe both of you do, maybe both of you can't stand each other. You cannot harbor ill will toward the other in front of your children. It is damaging. 9 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You do have to report as directed. I'm going to order that you continue your mental health treatment at the facility approved by probation. I'm going to order that you attend the domestic violence weekend program. This assault doesn't rise to that level of requiring 26 weeks. No contact with the victim except to effectuate visitation with the minor children in accordance with the order of the Wayne County Circuit Court. I can't believe, is there an order sharing custody at least right now?
We
Did you guys have a hearing on that?
haven't had I filed a motion for parenting time, and Judge Farr had just ruled and ordered parenting time and joint legal custody and said this, and then sent us to mediation, which is at the end.
So you got, there is an order from the circuit judge.
For parenting time and.
Okay. So you got, there's to be no contact except to effectuate visitation. I would like to think you two are adult enough where you can at least communicate with one another. I'll pick them up at 6. I'll drop them off at 4, whatever the case may be. But that's the order of the court. You're not to possess any firearms. You're not to possess any dangerous weapons. You're to serve 4 days jail credit, 1 serve 3. I'll let you serve those with community service. I'm going to give you till April the 30th to complete 24 hours of community service. We're going to give you a prosecutorial review date here in a minute. I'm going to order that you pay fines of $100, cost $200, $75 victims' rights fee, $50 justice assessment. So fines and costs are $4 1/4. Probation fees are $180 for $605, and then you have screening fee of $60. I'm not going to order the court work program. $665. If you violate, your probation could be revoked. I'm taking it under 7694A, as I said. If you comply, the case will be dismissed on motion of the prosecutor. The only agency that will be able to see that are police officers, judges, prosecutors, nobody else. It'll be a non-public record for all time. If you're compliant, the case is dismissed. If you violate, it can become non-public Like I said, your 769 status could be revoked, and then it will go on your record for all time. So, do we understand the sentence? Anybody have any questions?
No questions here.
Can she pay that today? 665.
A couple hundred today, Your Honor, but we should be able to get that taken care of, within 30.
I'll just give you till April 15th to pay it. Can you do that? You pay 200 today and then the balance by April 15th. You'll meet with probation. Give me the review hearing date if you will, Heather. So it should be out in
December 3rd. I'm sorry, Judge, I was muted.
December 3rd of 26 at 8:30. You don't have to come, Mr. Darren, if she's compliant. Okay, anything else? Did I miss anything, Ms. Alway? Mr. Darren, anything else?
Nothing further, Your Honor.
Ma'am, anything else? Sir, anything else? And I wish you guys well. I truly do. Hopefully, you're going to recognize children are much, 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 much more important than we are. Good luck. Thank
Your Honor,
you.
do you want me to take her to probation first, or does it?
Yeah, take her to probation.
When you step back and look at these two courtroom moments together, what stands out is how quickly ordinary situations can spiral into serious legal consequences. In the first situation, a tense confrontation inside a public store turned into a criminal case because someone chose intimidation over self-control. A single decision, walking in with a weapon and adopting a threatening stance, shifted everything from a manageable dispute to a matter of public safety. The courtroom reminder here is clear: actions taken in anger or impulse don't just scare people in the moment, they follow you long after the incident is over. In the second situation, the drama wasn't explosive, it was slow, painful, and deeply personal. Years of alleged manipulation, substance issues, and emotional conflict unfolded in front of the judge. What made it powerful wasn't shouting or chaos, but the weight of long-term damage. When family conflict turns into legal warfare, especially involving children, the court becomes less about punishment and more about drawing hard boundaries. The judge's frustration reflected something bigger. The system cannot fix personal resentment, but it will intervene when harm, control, or neglect crosses legal lines. Together, these hearings highlight two different forms of escalation, one sudden and physical, the other gradual and emotional. But both share the same lesson: the courtroom is often the final stop after people fail to resolve conflict responsibly. Whether it's a moment of aggression or years of toxic behavior, the legal system ultimately steps in to restore order, protect others, and impose consequences. And that's the underlying takeaway: choices, whether made in seconds or over decades, eventually demand accountability.